I do want to start off by saying thank you so much for being here. It's always a pleasure and an honor to just be in the midst of like great and amazing minds. Like, I'm sure you're here because, you're building something special and you're trying to protect that thing because, we live in very interesting times now, and it's kind of like you snooze, you lose kind of thing. And so I think, I think being proactive in really protecting the thing that you have poured so much of your sweat into, like we just heard about Allegra's, journey of 10 years. And many people don't start thinking about branding until like later into their journey as entrepreneurs. And so I think being proactive, regardless of where you are in your journey, I think now is always a great time to start. And so congratulations for being here. And I hope that you kind of open up your heart and your mind to really receive like and just get new insights. And because trust me, I've heard this presentation once and I can tell you I'm ready to learn more things, because you know how when you talk to Rookie or when you hear Rookie speak, there's just so much meat and so much goodies that you might not be able to like absorb all of them at the same time. And so like then you come back and you're like, oh yeah, that's more stuff. And so I have my notes ready to go because yeah, this is going to be amazing. But I am Ebere Shonoiki, and I am a business development officer with Working Solutions. And what we do at Working Solutions, we are the first to believe in small businesses. And what that means is we come alongside business owners like you and business owners who are either like at the starting point of their journey or regardless of where you are in their journey. And we support them with capital and with consulting. And these are two areas that we know that there's a huge gap in when you talk about disparity. And we're part of the CDFI community, and that stands for Community Development Financial Institution. And our goal in the Clinton administration, and our goal is to fill the gap and serve businesses that automatically or typically are not served by traditional banks for different reasons. And so we focus on people of color, we focus on women in business, we focus on startups, and we provide anywhere between $5,000 to $50,000 of capital to businesses to get started or to expand and grow their business. And then once you get qualified, if you get qualified for a loan, you have access to free business consulting for the lifetime of your loan with us. And we have been in this game for 20 years and going, and it's been an amazing impact to really see the impact that we get to have, especially even now with COVID, and seeing that the work we do is really, really relevant. And there are many people who would not have access to what they need to build and grow their businesses, except if they, except for organizations like Working Solutions. And so I'm really proud to be associated with this organization and really join the amazing team of people that really pour their heart into the work that we do. I always say everyone that comes through our door, like you're heard, you're seen, you're not just a number running through a system. Everyone, even people who don't get qualified for a loan per se, walk away with tips. We don't say no, we say, here's what you need to do. Go do X, Y, and Z, and then come back to us or go somewhere else. But these are the tips that you need to make you a better business owner, to get your business in a place where you're able to receive the funds that you need, the capital that you need to grow. And so I'm really honored to be a part of the team, and feel free to check us out. I think it's probably in the chat already. If it's not, I will put it in there. But information about where you can find out more about us, workingsolutions.org. We're on Instagram, we're on Facebook, we're on IG, we're all over. Okay. So even if you feel like you don't need the fund now, I think it's good to know where you can find it when you do need it. So definitely following us is something that you want to do. But without further ado, I am going to shut my mouth so that you can actually hear from Rukiatu Tijani. Rookie. I was getting ready this morning and I was like singing with her name because I'm like, Rookie, I was singing in Nigerian.
Yes, Ibere is my Nigerian sister. She's my Niger sister. So we need to dance a little bit now.
Yes. But I'm going to hand it over to you, Rookie, to take us on from here. Thank you for being here, Rookie.
First of all, thank you so much, Ibere, and thank you, Working Solutions, for having me. I am super excited to be here amongst change makers, founders, entrepreneurs. And I love Working Solutions because your mission of providing diverse entrepreneurs with affordable capital, with customized business coaching and community connections to increase economic opportunity, specifically in the San Francisco Bay Area, is something that speaks to me greatly. And I know it speaks to me because of our shared value and mission to help social entrepreneurs and diverse founders thrive. In fact, people tend to call us the Tom Shoes of law firms, and that for every paying client that we get, we provide free and low cost education in the form of courses and webinars just like this. So this is my jam. This is going to be a great conversation. I am going to ask you guys to get involved. I grew up in the Black church, so we do call a response in these conversations. So I am truly excited. But before we start, I want to share my story because we all have one, right? So here's a little bit about mine. I am a proud first-generation college graduate and a proud first-generation law school graduate, graduated from UC Berkeley School of Law. I'm also a proud Brooklyn native. And after a few years of being an attorney, I wanted to quit. I wanted to quit the law entirely. As the first in my family to attend law school, I just didn't know what I didn't know about navigating this new and nebulous space. And that, frankly, along with the abysmal lack of diversity, I didn't come to rooms that looked as beautiful as the one that I'm in now, made me want to quit. But mentors and friends and family, and frankly, some divine intervention convinced me eventually not to quit. So I went on and I joined the #1 litigation firm in the country and was highly successful as an intellectual property attorney in the Silicon Valley. And I loved it. I was in meetings with startups, VCs, and the darlings of Silicon Valley. But again, in virtually every space that I navigated to that point, those two lacked diversity. And diversity in thoughts, diversity in ideas, diversity in the backgrounds that I knew we all had. So I took the bold leap of faith and I left to start a venture, which is Firm for the Culture, which really doubles as my love letter to culture, creativity, and people who are really intentional about creating social impact. Essentially, it allows me to geek out for a second while still being colorful and fun and talking about Cardi B and trademarks and Meg Thee Stallion and Beyonce and all that great stuff. And it's specifically designed for the founder of today to protect their creativity as they make their mark on the world. So with that, again, Ibere and Working Solutions, thank you so much for having me. So let's jump right in. So you found out about me. So trademark law is for trendsetters and rule breakers. And it's true. So generally there are 3 types of intellectual property: patents, trademarks, and copyrights. Patents and copyrights, as I'll explain a little bit later, are generally limited in time. But trademarks, I like to say that trademarks are a business's best friend, just like diamonds can be a girl's best friend, because they are meant to last forever. Theoretically, if you pay the maintenance fees, they can last forever. Think about brands like Disney and Coca-Cola. The people who invented those brands are not necessarily alive today, but those brands are still growing, still going, and still monetizing their income and their impact for decades, if not centuries, because what they've had since the beginning is a trademark, a mark of their particular trades. And for businesses like yours, you can be like Disney or Coca-Cola. You're going into business to solve an issue. So this is my first call and response question. Tell me in the comments, what impact would you want to make with your business? Let's talk about it for a second. What kind of impact do you want to make with your business? I want to hear from you, Brittany, Denise, Allegra. Talk to me about the type of impact you want to make with your business. And I can start. So with Firm for the Culture, our business model is simple. It's really providing intellectual property assistance and services and strategic guidance to help a business scale and monetize their brand. So we start off by having you protect at its core your brand identity. And then once we help you protect your brand identity, we help you monetize your brand identity through licensing and assignment agreements so you can continue to scale your impact while making meaningful income for you and your family. So Allegra, tell me, can you hop on for a second? Tell me, if you want to, or you can type it in the comments. Tell me what impact you'd like to make with your business.
The impact that I'd like to make with Ottawa Publishing is to put a whole lot more author narrated audiobooks in the world, specifically titles that help people, content that helps people to make the world a better place. So that's why I specialize in nonfiction titles, because I feel like there's so much out there that, you know, there's so many books out there that are read by professional actors, but to have something that is narrated by the author, you know, having that really authentic voice is important. It's important to get that out there, you know, for especially for folks who are from marginalized communities, you know, that don't necessarily have their voices out there, you know, get them out there. So that's the impact that I intend to make. So
thank you so much, Allegra. And I love that you talked about how Ottawa is really helping the stories that like really are similar to a lot of diverse people get out into the world. I remember listening to Michelle Obama's book, Becoming, and I listened to it over and over specifically because Michelle Obama read her own audiobook. So I understand and I can identify with the power of what Chimamanda Ngozi Adichie says, sharing your own story, sharing your own narrative. So thank you so much, Allegra. And then Sherry talks about writing a series of children's travel guides. I want youth to be more trip savvy, to be better informed young travelers, and be more involved in the travel process. I love that, Sherry, because as a person who, my mom, even though we lived in the projects of Brooklyn, New York, she encouraged me to travel, my first trip being to Ghana, West Africa, and trips after that being to places like China and Paris and London. I totally understand and can identify with the power of traveling. And then Denise, you talked about having a plant-based ice cream business. You want to be able to change the way people look at food as medicine, as fuel. That's also something that I think a lot of us can identify with. As a person, again, who grew up in the projects, not having a lot of information about how to properly treat this temple that is my body is something that is encouraging me now to look more intentionally about what I'm eating. So thank you, thank you, thank you. And I think for the most part, we all can agree that in all the impact that we're making, we're not playing small. We're playing big, we're playing to win. And oftentimes we're not playing in just one particular area or one particular state. We're playing across state lines, we're playing nationally, and in some cases internationally. So we don't want our efforts to be stifled by a cease and desist or claims that somebody else essentially owns your brand. So in this presentation, I'm gonna talk about a couple of things. So let me just share the next slide. In this presentation, we're going to start with the basic. We're going to start with what a trademark is. And then we're going to start with the differences between trademarks, patents, and copyrights. And then I'm going to talk to you about the nitty-gritty, how to actually conduct a trademark search on the United States Patent and Trademark Office website, and what it means in my sense to prepare for the overflow. And I'll talk to you about like what my why is and my personal story as a founder and business owner. So let's jump right in. So what is a trademark? So a trademark at its core is a word, a phrase, a logo, design, sometimes even a color or sound that's used to differentiate your business from others. Now that is a mouthful. So what does that actually mean in real life? So a trademark is literally the mark of one's business or trade. So it's used to differentiate sometimes similar products or services from other similar products or services in the marketplace. So one example that I like to often talk about is with my favorite coffee company, Starbucks. So every so often we get a really, really awesome client who's looking to change the world, just like all of you guys in the comments. And when I get this awesome client that's inspiring me and motivating me, I know that I'm about to work really, really hard. So I go to Starbucks and I grab a venti Pike Place. And when I'm walking outside with this Starbucks coffee cup, I might position it in a way because I'm fancy and I want people to know that I got fancy coffee. And I might position my Starbucks cup in a way that allows people to see who are walking towards me that I have this coffee product that from a company that has its headquarters in Seattle, Washington. And without this person drinking my coffee or trying the product, they know that one, the company from which I bought this product from is from Seattle, Washington. They know that this company has a certain je ne sais quoi, and they know that this company is not McDonald's, even though McDonald's sells coffee. And they know that because the Green Mermaid is not the Golden Arches. They also know that this coffee company is not Dunkin' Donuts because, again, the Green Mermaid is not a pink and orange double D sign. And they also know that the coffee is not Peet's because the cup is not brown in nature and doesn't have the word Peet's on it. So that is the power of trademarks. Trademarks allows you to control and maintain your business narrative tied to something as simple or as complex as a logo, or sometimes even a color or sound or slogan or word. So another example that I like to throw out there is a sound. So trademarks can also be a sound. So let me know in the comments if you recognize a sound. So hopefully I don't sound crazy. Dun, 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 dun. So let me know in the comments what that sound is. Yes, Paramount, Paramount, Paramount. And that sound is actually a trademark because it's used to differentiate that studio or production company from other studios or production companies in the industry. Or what about this sound? Dun, dun, dun. What sound is that? Exactly, NBC. Those three gongs are actually federally registered at the United States Patent and Trademark Office, and it's used to differentiate that news production company from other news production companies in the same marketplace. So thank you. So with that, trademarks are one form of intellectual property. So what is the difference between a trademark, copyright, and patent? And again, a trademark is used to differentiate services or goods from other similar services or goods that allow each business to essentially control their own business narrative in association with such services or goods. Now, copyright, on the other hand, shows the world that a business or an individual made an artistic, literary, dramatic, musical, or creative composition or other intellectual work, whether published or unpublished, like a song, a book, a course, in Allegra's case, an audiobook, that they have the exclusive right to reproduce. Copyright literally means the right to copy, and it's come to mean the exclusive body of rights granted by law to copyright owners for protection of their work throughout the time of protection. And then patents, they protect what's called new and non-obvious inventions and they give the owner exclusive use of the invention throughout a limited time span. So new means that it's not generally disclosed to the public, and that's subject to certain limitations. And then non-obvious means it's not an obvious improvement or continuation off of what's already in the general field. So again, I'm going to come up with another analogy about the exact differences. Let's say that if you were anything like me at the beginning of the pandemic, you're watching a lot more Netflix than you care to admit. So I was watching Netflix on my TV in my living room, and that TV is actually a Sony TV. Now, to the extent that you see the word Sony in the lower center or on the box wrapping that the Sony TV was sold in, that is Sony Incorporated's trademark because it is a logo, a word, or a phrase that's used to differentiate that TV product from other TV products in the marketplace. So by virtue of you seeing the word Sony, you know that TV is not RCA or Toshiba, right? And then to the extent that the shows are coming out of Netflix or the shows are coming out in commercials or jingles about the songs, jingles or songs are being shown or in alignment with commercials on the TV, then that is copyright. That's a literary and artistic creative work in a fixed medium. The fixed medium being the song or the show or the movie. And then to the extent that I'm pressing multiple buttons on the TV, buttons to turn the TV on and off, buttons to control the granularity of the image that I'm seeing, buttons to even control the volume. Those buttons and the actual invention that is a TV is controlled by patent law because portions of the TV or the actual invention were new and non-obvious at the time that it was created. So I want to hear from you guys. Put a P in the chat If you think what you want is a patent, put a C if copyright, put a T if trademark, and put a combination of sorts if what you want is a trademark, copyright, and or patent. Denise says trademark, copyright. Brittany says trademark. Allegra says trademark. Amani says trademark. Awesome. Sherry, yes, you have a C. I think I need a T. Awesome. Well, we're just the person to talk to. So I want to now talk about how to conduct a trademark search using TESS, which stands for the Trademark Electronic Search System. So before I start, put a 1 in the box if you ever even attempted to conduct a TESS search or have some sense of how to conduct a TESS search, and put a 2 in the box if you're just like, Attorney Tajani or Rookie, girl, I don't even know what you're talking about. So tell me in the comments. Viola said 1, Sherry said 2, Brittany said 2, Imani said 1, Denise said 1. All right, so I'm actually going to show you. So let's go ahead and open up another quick tab. And can you see the screen that says, just nod yes, Trademark Electronic Search System? Can you see that? Okay. So the Trademark Electronic Search System is the first place that we go to in order to clear, at least as trademark attorneys, in order to clear a mark. And clearing a mark is pretty much us saying you can use it and you won't likely be sued for what's called a likelihood of confusion. So actually, let me kind of show you how to get to it. So the name of the website, because I have it in my cookies, so this is just something that pops up all the time, but you can actually start off by going to uspto.gov. And this is the little longer way to go about it, but I definitely want to make sure I show you. And then just go to trademarks. You can go to searching trademarks. And then you go to search trademark database, which is search our trademark database, which is TESS, or the Trademark Electronic Search System. So I'm going to go ahead and click on that. And that brings us right back to the original screen that we had. Now, there are 3 different options, but I'm going to start off with the simplest of them, which is a basic word mark search. So I'm going to press that. And we're just going to start off by putting in one of my favorite brands, Starbucks. And we're going to keep all the other options the same, and then we're just going to press submit query. And as of today, you see that there are 160 records that kind of match or at least have the word Starbucks in it at the United States Patent and Trademark Office site. Now I'm going to break down each column to give you a little bit more clarity and understanding as to what we're seeing. So the first column that you see is actually what's called the serial number column. Over 700,000 applications last year were filed at the United States Patent and Trademark Office. Every single one of those applications were given a serial number. A serial number allows you to track the application throughout the life of the trademark prosecution or filing process with the United States Patent and Trademark Office. So as soon as you apply at the USPTO, you will automatically be given a serial number, and that serial number is going to live with your application throughout the life of your application process. But not every number or not every application that gets a serial number gets a registration number. So according to the Wall Street News, or according to the Wall Street Journal, about 50% of applications that get filed with the USPTO don't actually mature into registration, particularly if they're done by people who are not assisted with trademark attorneys. And that's for various reasons, and I can start to break that down in a few minutes. But with that said, not every application matures into a registration, so not every application gets a registration number. As you may or may not know, the registration process is a long one, and it's actually getting longer and longer by the day. In the past, it used to take about a year to a year and a half for the full application process to start, from the time you filed, the time you obtain that serial number, to the time you are finally registered, the time you obtain that registration number. But last year, over 700,000 applications were filed, which was a record-breaking number. And just this quarter, Q1 of 2021, over 200,000 applications were filed, which means that if we're going to continue to go by this trend, at least 800,000 applications, so about 1 million applications are going to be filed with the USPTO. So the process may be a little longer, and there may be a lot more applications by which the USPTO might see as a basis to block your application from going forward. So because of that, not every application is given in a serial number. The third column is called the word mark column. So to the extent that there are any literal elements, what the USPTO will call literal elements, which are basic English letters, words, and symbols in the mark, then those portions of the mark are here. You might notice that application or registration 11 doesn't have anything here. And that's because, as I would guess, there are no English literal elements in that mark. So let's actually open that up. And as you can see, there are no English literal elements in that mark. The mark is actually in Chinese and it means Starbucks, Starbucks coffee in English. And that same kind of literal translation can also happen to marks that have no words in them. So think about the Nike swoosh sign, for instance. That mark has no words in it. So you wouldn't necessarily see Nike or any other literal element over here, but you would have to open it up to see the Nike swoosh, right? Or the double arches without the word McDonald's. And so that's what the third column is about. The fourth column, I like to call the fourth column the TMZ, or the shade room of the trademark world. And that is the trademark search and document retrieval system. And that allows us as trademark attorneys, or anyone who essentially comes to this website, to see the good, bad, and the ugly with regard to any application at the USPTO. So that allows us to see how you applied, if you got any rejections, if you were stopped, if there was a likelihood of confusion with another mark in the marketplace, and if you should still be using your mark. Because if we were to find that there was a likelihood of confusion with another mark, me as a trademark attorney, I can use this that as a basis to essentially send you a cease and desist to not only stop using the mark, but to threaten you with a lawsuit for 3 times the amount of damages tied to any profit that you got by virtue of using what the USPTO has deemed, per this public document, a confusingly similar mark. So that is the TSDR. And then the last column is the live or dead column. So a live application means it's an application that is essentially just filed and still going through this 1 to 1.5 year long process, and has been registered. So you see number 10 has been registered, and the company that owns the mark is still utilizing the mark in the marketplace. So the name of the game in trademarks is use it or lose it. So if you don't actually use your mark, if you don't actually use the brand name in association with the goods and services, you can actually lose your rights to federal registration or your trademark in general. So applications that have gotten a registration date that are still live indicates to us as trademark attorneys that the person or company that owns the mark is still very much using the mark in the marketplace. So we should steer clear of using anything similar or identical to that mark. On the other hand, if the mark is dead, that means generally that the mark will not be used as a basis to stop your mark or any similar mark from being registered at the USPTO. And a mark can be dead for a various number of reasons. One main reason is that a mark application gets abandoned. The applicant maybe gets cold feet. They got an initial rejection from the USPTO. They don't necessarily know how to overcome that rejection, so they abandon the mark. And when you abandon the mark, you essentially lose all federal benefits associated with the mark, which means that if you wanted to get a federal registration, you would have to start all the way from the beginning. And if you start all the way from the beginning, remember, you're coming after the 700,000 applications that were filed last year, which means that you get a heightened likelihood of confusion refusal. So that is a little bit about the USPTO. And that is how to engage a clearance search, an initial clearance search at the USPTO. So I know a lot of you are probably thinking, okay, you just showed me the game. Why do I need you? Why do I need you as an attorney? I can just search on this very, very public website. Well, TESS is a great tool, but it's not the only tool that we use when clearing your mark. And the reason why is because it's relatively limited in what it provides you in terms of analysis. And it only actually shoots out what you put in. So let's say, for instance, you wanted to, again, trademark the word Starbucks, but you wanted to trademark it not only with just one S at the end, but with two S's at the end, right? And let's press submit query. Now you'll see no test records were found to match the criteria of your query. And if you geek out on the test website like me, you'll see that this same exact screen is actually shown when there are no conflicting marks. So this same exact screen can be shown when there are confusing marks or similar marks or identical marks, and when there are no conflicting marks. So with that, if you were to try to apply for the mark Starbucks with two S's, not only would you get stopped at the USPTO, you may get a nice cease and desist letter from that Seattle-based organization. And in the same way, I just want to show you a couple more searches. Searches like GIRL may not pull up searches like GURL or GYRL, right? So it's very important to engage strategy to determine not only what the commercial impression or general interpretations of your mark entail, but also the goods and services. It may be entirely possible that you may have goods and services that are related to another mark's goods and services, even though you may say that they're different. One example that comes up for me is, I think it was Kanye West's, Sunday Service. Is that the name of his mark? Sunday Service or Sunday Sermons or something. And I remember, and he was doing it in association with, clothing, like t-shirts and shoes and what have you. And the USPTO found his mark was confusingly similar to another organization that was like a DJing music service, also called Sunday Services. Now, clothing and music may not necessarily be related in the traditional sense, but think about the marketplace. When you go to concerts, what's typically sold in the back? T-shirts, merch, clothing. So the USPTO deemed those goods and services very similar. And because they're deemed similar, me as a trademark attorney, I would automatically assume, okay, not only am I looking at what's called the entertainment and education class, which is typically class 41, I'm also looking at the clothing and apparel class, which is class 25. So there's a lot of strategy that goes on behind this. And I wanna pull up my other notes to kind of show you what that strategy entails. So in addition to searching at the USPTO, at the very least at Firm for the Culture, what we do is also conduct a trademark comprehensive search clearance report analysis. So hopefully it pulls up because I'm not trying to look crazy in this presentation. And just to give you a sense of what this is going to entail, at Firm for the Culture, we don't only just talk the talk, we walk the walk as well. So even before we started, we did our own analysis for our own mark, and we filed an application for our own mark, and we engaged the analysis and the strategy that I'm talking to you about today. So this is what's called a comprehensive search report, and it's searched for Firm for the Culture in multiple classes, including legal services. And as you can probably see, I don't know if and it's over 300 pages long. 311 pages long. So we were looking at essentially every and any mark that could possibly be deemed as identical or similar to our mark. And we looked at various marks, including For the Culture, the Firm for Men, the Firm for Biz, Fly for the Culture, Yoga for the Culture, Counsel for the Culture, that's really similar, Only for the Culture. And we utilize all of this information to strategize as to how we were going to articulate our goods and services in such a way as to avoid what's called a likelihood of confusion, refusal, or 2D refusal. And once we filed, we got that serial number, just like I said, every application gets. And after a few months, we then got this very, very pretty, hopefully it comes up, registration. So we got this very, very pretty registration that hopefully will load in a minute. I think it's coming. I should have made this a window already. So that's the Firm for the Culture registration. And that gives us several benefits. We could essentially stop anyone in the industry from essentially having legal services that are marketed or sold under anything sounding like For the Culture or Firm for the Culture. So let me know in the chat if you guys want one of these certificates. Type yes if you do, and type no if you're simply not ready or want some more time to think about it. And I also want to do a screen share. We got a bunch of great, hold up. Let's see. Here it is. Do you see this? We got a bunch of great yeses. So we got the Search 101. So, and I know a couple of you guys are probably thinking, and let me just make sure I keep this. Forgive me. Trying to do this screen share right. Okay. Okay. I don't know if you can see my notes. Can you see my notes? Like if I go to the next screen, just, okay.
I see a cool orange jumpsuit.
Okay, awesome, awesome. So I want to talk about like just why I'm prompting you explicitly to say yes. And I want to talk to you a little bit about what I call preparing for the overflow. So as you know, I am an alum of corporate America. I'm an alum of Big Law. I worked as an IP attorney in the Silicon Valley in the #1 litigation firm in the country. And when I was at this big law firm, I started an organization called the First Generation Purpose Project, which is an initiative designed to help first generation professionals navigate life and career by utilizing the grit and tenacity that's already in the inside of them. And when I started, like many business owners, I had no idea where it would take me. But I'll just say this, I was definitely not prepared. Within a few months of beginning, I landed my first client, which was interestingly enough, Yale Law School. And here I am, this girl from Brooklyn, New York, didn't know that I was going to land my first client, which was the top law school in the whole country. And I just thought that was a fluke. I thought it was a fluke. I didn't think that it was going to be this commonplace thing until my next client. So I'm going to also show you, I had this picture from my mama. She was excited about that, Yale Law School, until my next client was the United States Department of Justice. So I'm doing this talk on this stage in Washington, D.C. I was essentially a paid speaker, and I was on the same stage as the US Treasurer, like literally the person that signs our money. I was on the same stage as Jovita Carranza and Jay Clayton, who was the chairman of the Securities and Exchange Commission. But even then, I still thought, okay, this is a fluke. Let me just do these talks and go home, not necessarily having in my mind that I needed to prepare the structures and the systems and have my processes down and have my trademark protected. So again, still kind of going by the seat of my pants and doing all these talks, getting paid, getting flown around. And then shortly after that, I was asked to go to the University of Notre Dame to give a talk as a first generation professional, essentially talking to other first gen professionals and law students about how to successfully navigate their career in corporate America. So I did that at the University of Notre Dame, gave this talk, again, still thinking it was a fluke until the California Change Lawyers called me. And they said that I had been honored as a California Change Lawyer for essentially increasing diversity in the legal fields in California and throughout the country. And also, the Senator of California also honored me for First Generation Purpose Project. And I got I got recognition by the California legislature. So why am I showing you all of this? Because I think many people think that there are going to be significant failures before starting your business. And that might very well be the case. There may be times where the product doesn't sell as well as you wanted it, or the people don't show up to the presentation as much as you wanted them to, or the execution of your services didn't go as planned. And in fact, if I'm being honest, despite all of this, what happened to me less than a month ago is I gave a presentation in a virtual room for trademarks of literally 0 people. And I was in this room and I'm walking through people through the application process and I'm bringing them to test just like I did for you. And it was literally 0 people. I think one person came and then they left. But even despite the setbacks, with Firm for the Culture, I succeeded and built a multi-6-figure firm within just 8 months of opening the doors. And with First Generation Purpose Project, I was able to have all of these amazing opportunities within less than a year of opening my doors. And it was only after that I thought, maybe I should trademark. And I remember going to the USPTO and filing my application. And although I was a litigator, which is a very, very different thing than what I do now, I assumed I was just, I went to the USPTO and I said, I can file this, no problem, I can do this. I'm a lawyer. I got rejected. So my application almost ended up dead, just like you saw on that screen. And it scared me because all of this stuff fame and recognition that I had accumulated over the last year could have been lost if I had lost the rights to my name, First Generation Purpose Project. So I studied really, really hard. After panicking and crying, and I did significant research and I overcame that initial rejection. And then I got another rejection. The USPTO said that my mark was quote unquote confusingly similar to another mark on the USPTO. And that's when I got mad. That's when the Brooklyn girl came out of me. And I really did significantly more research. And I actually ended up giving a 200-page brief with evidence and arguments saying, no, it doesn't sound similar, it's that. And eventually I got the registration. So I eventually got the registration for the First Generation Purpose Project, which means that I essentially own my name and I can stop others from utilizing anything similar in relation to speeches or speaking events or services of that matter. So it's easy to do it the easy way. It's easy to, either go to LegalZoom or just try to go by the seat of your pants. But I'm asking you, are you properly positioned to simply receive the overflow, which is going to come? The fact of the matter is, if you're in this room, if you are intentional about creating a business that really makes meaningful impact, you're doing it to play big. I talked to you in the beginning about some of the things that you're doing. You are helping children travel. You are helping children understand the beauty of travel. You are helping people shape their own narratives through their own voices and their own story, right? You're doing things that are simply meaningful for our generation and beyond. It's time to prepare for the overflow. Do you have your trademarks in place? Are your contracts drafted? Are your systems and processes in place? If not, frankly, you may be subject to trademark infringement, which is what happened to a few of my clients after 3 to 4 years of not having filed their trademark. And their process was significantly more expensive because they didn't take the steps to protect their mark before becoming a household name. For one client, I actually have a podcast episode, and I'll share the link in the comments, but imagine getting your millionth podcast episode download and then being told that you have to change your name, or you'll get sued for 3 times the amount of damages or the amount of profit that you gain from this podcast. That's what happened. And I'll again drop the link. Or think about contractual liability, which is what happened to another client who had a business divorce. We like to call it a business divorce with her business partner after not having a firm dissolution or break of partnership provision in their partnership contract template that they bought offline without having an attorney review it. So again, it's easy to do it the easy way, but are you prepared to invest when no one is watching? Are you prepared to invest when no one is clapping? Are you prepared to invest when you're in the empty room? So I'm gonna get off my soapbox, I promise you, but I'm saying this as one business owner to the other. Prepare for the overflow. Prepare for it. Your investment will thank you. So in the meantime, here are a couple of ways by which you can prepare for the overflow. Trademark your brands, including different variations. That's going to prevent huge litigation or a lot of confusion in the marketplace. A few weeks ago, I gave a presentation about Nipsey Hussle, and I talked about a trademark issue that his estate is grappling with. They have a registration for the marathon in association with clothing, but not for the marathon continues, which is what Nipsey Hussle is known for. And because of that, the Crips, yes, the gang, the Crips, they're actually an official LLC, decided to file an application for the marathon continues. So now the Crips and Nipsey are in a fight over the marathon continues. So definitely trademark your brand, including different variations. Police your mark consistently. Just because you have an application or registration at the USPTO, it doesn't necessarily mean it's the end of the battle. You have to police your mark by either sending cease and desist or telling people in a nice way, maybe through social media, to stop using similar hashtags or identical or similar brand names to yours, because it could actually serve to dilute the commercial impression of your mark. So make sure you're policing it consistently. And then also, use your brand consistently. We talked about this in the beginning. You don't want that dead indicator at the USPTO. So trademarks, it's use it or lose it. So if you're going to be in this business, continue to use your brand in association with your goods or services. So you can tell the USPTO that you have what's needed to have your mark receive longevity and sustainability, just like Disney and just like Pepsi and just like other brands that are receiving significant recognition. So that is it. Let's get our generational wealth on together for the culture. So let me know if you have any questions, and I'll go into the chat. So we got a lot of great stuff.
Yeah. Thank you so much, Ruki, for sharing. And you guys, we have another 12 minutes. So I know you have a lot of questions. So get it going. Ruki, remember the one you shared in your last presentation? I heard about Black Lives Matter.
Yes.
That stayed with me. Like, it stayed with me.
Yes, and I can talk a little bit about it. So one of the growing types of rejections that can actually serve to get your application deemed as dead or abandoned is what's called the failure to function rejection. So essentially that means that your brand, and I love that you mentioned that, Abere, because that really ties to the prepare for the overflow. That rejection typically comes to brands that get too famous or too commonplace. So at its base, the principle stands for the proposition that if everyone is essentially allowed to use your brand because it's received household notoriety, household recognition, largely because you failed to protect the mark before it got super famous, no one, including you, should be allowed to own the mark. So famous marks include Meg Thee Stallion, Hot Girl Summer, or Taco Tuesday by LeBron James, or even Okrr by Cardi B, and specific to social impact founders that happened with Black Lives Matter. So Black Lives Matter was founded in 2013 by Alicia Garza, Patrisse Cullors, and Opal Tometi. And it was found largely after the shooting death of Trayvon Martin and the acquittal of George Zimmerman. And they didn't trademark their brand, even despite, Eric Garner's shooting, Eric Garner's death in 2014, Michael Brown's death in 2014, Sandra Bland's death in 2015, the presidential election between Trump and Hillary in 2016, where Black Lives Matter was consistently on the national stage shouting that our Black lives matter. They didn't file for registration until October 2017. Less than 6 months later, they got hit with the failure to function refusal. And the USPTO cited much of their fame in rejecting their mark. They said the Black Lives Matter movement has pushed itself into the national conversation again and again. It seems like anyone can join them, and anyone can thereby claim to be a part of the movement simply by creating a Facebook page or using a hashtag. So they couldn't own the brand Black Lives Matter, which means that they couldn't stop people who may have used it incorrectly or out of alignment with the values of the Black Lives Matter movement from using the words. So fast forward to 2020, right? COVID is happening. George Floyd is on the national stage, and there's a bunch of civil unrest. An organization, that's actually a generous characterization. An individual who lives in Santa Clarita, California, started a Black Lives Matter GoFundMe page, and he got over $4.4 million in donations that was misdirected from the actual Black Lives Matter global network, which is the official Black Lives Matter. This Santa Clarita Dude's GoFundMe page was the Black Lives Matter Foundation, which is very different from the Black Lives Matter Global Network. And he got donations from Apple, Google, Microsoft. And again, over $4.4 million was misdirected to the wrong Black Lives Matter organization. So that's really what we talk about in preparing for the overflow. And I want to also talk about another person who did prepare for the overflow. I'm Brooklyn, so I have to give him up. Jay-Z. Jay-Z avoided the refusal by trademarking his stage name before he got too famous. So Jay-Z, also known as Sean Corey Carter, who grew up less than 20 minutes away from where I live, is an American rapper, songwriter, producer, entrepreneur. And his rise to fame happened in the 1990s. And in 2000, around the time that Jay-Z released the Dynasty Rock La Familia, he trademarked his own stage name. Now today, Jay-Z owns at least 4 federally registered trademarks to his own name, all of which allow him to monetize the term Jay-Z with a variety of products, including paper and stationery, clothing, musical recordings, live musical performances. And that's what allowed him to be a businessman. That's what allowed him to not, this is the corny part of me. This is what allowed him to not simply be a businessman, but a business man. I'm sorry. So, and he recently became one of the world's first Black hip hop billionaires. So again, that's what it means to prepare for the overflow. So thank you so much for talking about that again. Somebody said bars.
There are lots of questions in the chat, so you can.
Yeah, so we got a few questions. So this was an awesome presentation. Thank you, Sherry. What do you charge for filing a trademark application? So our flat fees are located on our website, but I'll just say it right now, it's $3,000. And what that allows us to do is be with you throughout the entire application process, which means unlimited calls, unlimited consultations, unlimited discussions regarding your mark, and significant brand strategy for the entire year to year and a half. So we're going to be with you until the time you receive your registration from the beginning. So that's what that flat fee covers. The next step would be to contact your office. Awesome. And the way you can do that is by going to firmfortheculture.com/book and go ahead and sign up for a call there. Thank you, Sherry. Denise, how do you determine how many variations you will need for your trademark? I have my business name and then 3 product lines under my business. Do I need a copyright to protect the content that will be my ice cream pints and a half pints bars? Okay, so the first one, how do you determine how many variations? So if you actually look in the upper left-hand corner of this screen, you'll actually see my name or the business name, Firm for the Culture. You'll also see it in kind of what's called 2 variations. You'll see the actual, the literal words, Firm for the Culture, and then you'll see it in a design with the logo. So those are actually 2 different trademark applications because the USPTO would deem it as the literal words, so just the words Firm for the Culture, if I wanted to protect Firm for the Culture itself, and then Firm for the Culture in what's called the stylized or designed format. So that's at least 2. And having it in that way, just the literal words, allows me to have Firm for the Culture in virtually any reasonable variation. So if I wanted to make it pink for Breast Cancer Awareness Month, or red for AIDS Awareness Month, or red and green for Christmas, I can have Firm for the Culture in all those colors, and because the underlying elements, the underlying words will be protected, it won't be any, I won't lose my rights to the mark because I have it in all those different variations. On the other hand, if I were to file the application as a logo itself, then if I theoretically had it without this like kind of culture, this little culture on the side, then I would risk losing my rights to the mark because I am not presenting it in a way that reflects how I applied for registration at the USPTO. And then another thing that you may want to consider, and this was what we talk about in terms of brand strategy, because a lot of our clients, they may have limited resources, limited funds, and they want to see which one they prioritize first. Another thing that I generally ask clients is, how are you showing up in the marketplace? What do people see most of? Do people see your logo first? Do they see your words first? Do they see a variation of them first? And let's strategize there too. And even outside of that general like fact specific question, I might even generally tell people it's probably best to trademark your literal words of your business before you trademark your logo. And the reason why is because the literal words of your business, as I showed you in the example a couple of seconds ago, is you can have any reasonable variation of the literal words of your business because the underlying words are protected. So if I were to change the Firm for the Culture logo to, you know, all pink tomorrow, because Firm for the Culture as an application, as the literal words is protected, I can do that without fear that I may lose my rights to the federal trademark or that I may otherwise dilute my rights. So hopefully that makes a little sense. And you said, do I need a copyright to protect the content that will be on my ice cream pint and a half? So I'm not a copyright attorney. So I would say take this with a grain of salt. And I would tell you to talk to a general copyright attorney more so about that. We are opening up that practice area soon, so I'll be able to give you that answer very shortly. But in the meantime, I know that copyright protects the literal and artistic elements in a fixed medium. And I remember a copyright friend telling me it may not necessarily protect the recipe. So you definitely want to talk to a copyright attorney about exactly what the content entails and how it's presented and if it's protected by copyright law. So hopefully that answers your question. What about website URLs? Should they be trademarked or not? So the website URL in and of itself, that's interesting. It's not in and of itself a trademark, but through the Uniform Dispute Resolution proceeding, if I were to have a trademark in Firm, because I have a trademark in Firm for the Culture, if you were to actually have a domain that's very similar to my brand name, Firm for the Culture, I can actually force you to relinquish that domain because it may be misdirecting consumers from my brand to your brand and diluting my mark. So while the URL in and of itself may not necessarily be a trademark, because a URL in and of itself is not necessarily associated with goods or services, which is what's needed for a trademark, you could still be in violation of somebody else's trademark rights if you were to just domain squat or try to sell them back the domain or try to use the domain in a way that confuses consumers in the marketplace. So the URL, it can be trademarked, but it's not necessarily a trademark. One example that I'm thinking of actually was a recent Supreme Court case around booking.com. So booking.com, it had other issues in it, like whether the word booking was generic and what have you. But essentially the Supreme Court said booking.com could be trademarked or registered. So the answer is yes, it can generally be registered, but in and of itself, it's not a registered, I hope I'm not confusing it. The trademark standing alone or the domain standing alone is not a trademark unless you tag it with goods and services. So hopefully that answers your question. Does the 3K include all applications for the different variations? It does not. It includes one application and includes the comprehensive search, the strategy, and the filing. So any other questions?
Viola had a question that she sent to me before she had to leave. She asked if the presentation will be made available to the attendees.
You can tell them, sure. I can, feel free, yeah.
Okay, I mean like the PDF or like, yeah, if.
Oh, the presentation.
Like the presentation itself.
Oh, the actual, I think my team can like download it into a PDF format and send it over to you, yeah.
Okay.
That should be fine.
Thank you.
Any other questions?
Awesome. Well,
tagged with goods and services. So Cindy, so what that essentially means, so let's say, you know, one of the questions that I typically get asked in that specific context is, can hashtags be trademarked or registered? So let's say that you had a hashtag that goes viral on Twitter, right? And you then say, okay, I created this, I started this, so this is mine, and I can stop others from using it. Not necessarily, because unless you put that hashtag word on a shirt and sell it, or on a podcast and produce it and provide it to consumers, or in association with any other good or service, that's not protected by trademark law. Trademarks or words that theoretically have the potential to be trademarked can't exist in a vacuum. So that would be called what's called a trademark in gross. So it has to be tagged. There has to be some type of good or service that the brand is being sold with in order to receive trademark protection. So for instance, Firm for the Culture, it can't exist in and of itself. It has to be sold with, in my case, legal services in order for me to receive protection from the USPTO. So that's what I mean by tagged with goods and services. So hopefully that makes sense. Are we still getting the trademark guide you spoke about in the beginning? Yeah, so I'm gonna work with the Barry to get that to you guys.
Awesome.
All right.
Wow. We are so grateful, Ruki, attorney Ruki Tijani-esque, like all of it, like you embody all of it, and just your passion to really get these, not the knowledge and the service that you bring is really truly needed, especially with businesses and entrepreneurs that might not have access to just even this way of doing business, or investing in your business way ahead of time. And so thank you for the reminder. Thank you for this has been a learning experience for all of us, and I'm grateful that we get to partner with you in the work that you do. You guys, we'll work with Ruki Firm for the Culture, their team, to get the presentation to you and everything that you need to get in touch with both Firm for the Culture and ForWorking Solutions. Okay. Well, thank you so much for your time. This has been an amazing time.
Oh, this was so fun. I love this. I love this. Thank you so much, everyone. Thank you, Working Solutions. And also, if you wanted the guide now, you can actually text culture to 33777 and you can get the guide essentially in your text messages or right away. But in the meantime, we'll also just make sure we'll send you the guide as well. But this is fun. I love this. Ibere Working Solutions, thank you so much for this awesome opportunity.
Awesome. Well, enjoy the rest of your day, everybody, and enjoy the Small Business Week.